Court reporter. Thank you. This is the January 29th, 2020 formal meeting of the Utah Board of Oil, Gas, and Mining. And our first agenda item is the per acre bonding costs for small mines and exploration. Take appearances of counsel.
Thomas Kessinger, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Thank you. Proceed.
So what you're about to hear today from Mr. Wayne Western is a process that's required by statute, and it's a presentation that you'll hear, and then at the end of it, you'll be asked to adopt the surety amounts for small mines and exploration projects. So with that, I will turn the time over to Mr. Western.
Here, I don't hear you on the mic. Let's double check that it's working.
Okay, can you hear me now?
Not very well. Just a little closer.
Okay, can you hear me now?
Yes.
Okay. Mr. Chairman and fellow members of the board, my name is Wayne Western, and I'm here to present the per acre costs for small mines and exploration. I believe most of you have been through these presentations a couple of times. For calculating the bonds for small mines and reclamation projects, by statute, there are two ways to do it. One is a per acre cost, and this is a benefit to many small miners who don't have the expertise or it would be financially adverse for them to hire a consultant to come out and do a detailed cost reclamation estimate. And the other is a site-specific calculation, which some miners are given the opportunity to do if they have a unique circumstance. Most decide to use our per acre cost. This is required under Title 40, Chapter 8, Section 14(1)(c), and it's so that the board will establish the bond. The division will give a presentation, and this also gives an opportunity for the public to have comment. Okay. The way that we go about coming up with these figures is we have produced a model mine, and the assumptions are that we are going to be working with either a 5 or 10 acre model mine for exploration, reclamation. There are no surface facilities. If there are, then that's a specific line item. There are also no leach pads or any complications, and the equipment that will be used is readily available. For 5 acres or less, we just use an excavator. For areas over 5 acres, we use an excavator and a dozer, which we found from experiences is the type of equipment that is needed. Okay, for a small mine, we have direct costs, and those involve earthwork, revegetation. Sometimes there's a portal closure, hole plugging, and occasionally you will have some surface facilities that have to be removed. Those portals, hole plugging, and surface facilities removal are line items which are added. For the equipment, we assume that there's going to be haul distances are going to be minor, so there is not going to be a need for trucks or loaders. The dozers can push the materials. Excavators will be used for basically digging. We also include a pickup truck for support, and we have the equipment operators plus 1 laborer. For the model mine that is 5 acres, we assume that you are going to have an excavator that will go through 10 hours of road work, 9 hours of high wall reduction, 7 hours for drainage, 15 hours for grading, and 9 hours for pocking, for a total of 50 hours. For the areas 6 to 10 acres, we will be using the dozer. The dozer will have 25 hours of backfill, 10 hours of topsoil placement, and 10 hours of ripping. We use Equipment Watch and also Blue Book. These are the same references that the CULT program has been using for the past 25 years. The vegetation amounts we assume are going to be $500 per acre when seeding occurs in conjunction with regrading and earthwork, and $1,000 when seedbed preparation is required after the initial grading. For portal closures, we've used AML's costs and come up with estimates for small portal closures, portals up to 36 square feet, shafts up to 6 feet in diameter. We do have additional calculations that we can use for structures that are larger. Surface facilities, I said that we assume that they're going to be no or minimal, and if demolition is required, then that's an additional line item. Mob distances, we assume that have been calculated in up to 50 miles. For increments of 50 miles, we've come up with additional costs. Our indirect costs are 10% for contingency, 2.5% for engineering redesign, 6.8% for main office, and 2.5% for others. The escalation costs are based on historical values. We use means construction cost index for this year. The inflation's gone up a little bit, so it's 2.95% per year. For small mines, we bond for either a 3 or a 5 year escalation period. The numbers have come out as follows. For small mines, the first acre is $8,800 for 3 years, and $9,300 for 5 year escalation, and then for the additional per acre, it's $5,600 per acre for 3 years, $6,000 for 5 years. For a small mine that has 5 acres, the total will be $31,200 for a 3 year escalation, $33,300 for a 5 year escalation. For a small mine, going from 6 to 10 for the 6th acre, because of the additional cost of mobilizing in a dozer, there is a bump. The cost would be $41,900 for 3 year, $44,700 for a 5 year. With each additional acre would be $6,800 for 3 years, $7,200 for a 5 year. For a total of 10 acres, it would be $69,100 3 year escalations, $73,500 for a 5 year escalation. For exploration, based on those, we assume a 1 year escalation period because permits are usually only good for between 1 and 2 years. So the first acre would be $8,300, and then for each additional, it would be $5,400. In conclusion, the method of determining per acre costs has remained unchanged. We've used it now for I think 10 years, and we've had very good results with getting the money in. There has been an increase from 2019. As we all know, costs are going up. And what I propose is that the board approve that the per acre cost amount presented by the board be adopted for the new amounts until we have an opportunity to present in 2021. Any questions?
Board members, any questions? Yes, on the right side, Mr. Hanson.
Wayne, I just had a quick question on the MOB, demob. 50 miles from where?
Okay, we assume that it's going to be 50 miles from a facility where you can rent Caterpillar equipment or another large city.
Okay, thank you.
Other questions? Just a couple of comment, request, and question. The request is, can I get an electronic copy of the Blue Book numbers that you're using?
Yes, we can get you the actual numbers that we're using. We'll be able, yeah, we could,
I'd like to see how that works.
right.
Okay?
Okay.
The second question, what's that?
Were you asking for the means numbers, means catalog numbers?
Well, there was the RS means, which was labor, and then there's the equipment. I guess it's the combination. I'm assuming that there's like per hour rates for like a dozer,
Yes, we have the calculations.
excavator.
Yes, we have the calculations for those for the model mines that list the means reference numbers. They list the blue book numbers.
That's what I'm looking for.
Yeah, and shows how the calculations are done. We can get you an electronic copy of that.
Just an email copy.
Sure, that's
Am I asking the right question?
I just wanted to make sure that what you were asking for is what.
Well, here's my assumption. The assumption is that there's a per hour field price for the equipment, and there's an hour per hour price for the operator.
Yeah,
And the operator's under RS means, and the blue book is the equipment. Is that correct?
yeah. That I wanted to make sure that you got both
Yes.
Yes.
both of the data so we could look at that.
Okay. And then, second item, one of the things I haven't seen in here is a comparison of actuals. Has anything happened in the last year that tested our numbers based on actual costs?
we've had a few, and they're generally coming out pretty much on target for our costs. So we'll go in and find the instances where we've had to reclaim using forfeiture money and show you what the bond amount was and then what the bid came in.
So the question, the bottom line question is, are the people of Utah being protected by this program? Have we had any underages where we've had to go to some other funding source other than the bond to get the work done?
So far, it's been pretty good. Dana, would you like to comment on that?
It's not whether you'd like to or not, will you?
Sorry, Dana Dean, Deputy Director over the mining programs. The cases where we have been underbonded have been cases where someone has mined outside of their permit area or done something that is inconsistent with the permit. In the cases where we have pulled a bond and done the reclamation and they were within their proposed disturbance and they were following their permit, we have had adequate bonds. So we feel comfortable with these numbers. We do feel that it is very important for the division to inspect and make sure that people are not going outside of their permit areas. And like I said earlier this morning, we're trying to apply some of the principles that the oil and gas program is using to use more data to help us catch those before they get too out of whack. But I would say when someone's following their permit, these numbers are very close. We have not been over bonded or under bonded in any appreciable amount.
And the last question I have, and then we'll go back to the other board members. I invite any of you and the board to respond to this, but in my experience on dirt work, major projects, we always build in a 10% contingency just for things that you never know coming up more than 50 miles from a base or something else. I didn't see that in here, and I don't know that I'm proposing it, other than on other projects that I've been involved with, I do see a 10% contingency factor just for something that you don't know what's going to happen. Anyone want to comment on that? Or is that in there and I missed it?
We do have a 10% contingency.
Where was that? I missed it then.
It's under, let's see, under direct.
Then,
Okay, there it is.
okay.
indirect costs. So we do have a 10% contingency in there.
Okay, then that answers my question. Okay, Rich?
I just second something Roland had talked about. I think it would be really useful next year when you're giving this presentation if you could actually present a table or a graph showing the real numbers, the real costs you've incurred doing reclamation versus what was bonded or predicted at the time, just to show that really good correlation if that's the case.
Thank you. Any other comments on the left, on the right? Yes, Mr. Hanson.
I just wanted to thank you, Wayne, Mr. Western, for the work you've done. I know this is a very tedious and long process, and you're always checking your numbers, and we've worked together for probably longer than either of us would want to admit, but thank you for the good work that you've done on this.
Oh, thank you.
Thank you very much for that. Board members, if there's no other questions, the matter before you is to vote whether you approve this program or would like to make changes. We're now open for a motion.
I'd move that we approve the program as presented.
Is there a second to that?
Second.
Any discussion? The motion before you is to approve the average cost per acre for reclamation as proposed by the division. All in favor say aye.
Aye.
Any opposed? Let the record show that was unanimous. Thank you very much. Appreciate that presentation.
Thank you for the opportunity to present.
Thank you.
The second agenda item has been continued, but, pardon me, is continued from the December hearing. So we're on agenda item number 2, docket number 2019-024, cause number RMNRL-2019-01, in the matter of formal rulemaking to amend the mineral program rules pertaining to suspension of operation. We'll take appearances at this time.
Thomas Kessinger, Assistant Attorney General for the Division of Oil, Gas, and Mining. And if you give me just one moment to get my presentation set up.
Yes, of course. Any other involvement from? Seeing none, as soon as you're ready, Mr. Kessinger, would you proceed?
Okay, it should just be a few moments. All right, thank you very much for your time. Mr. Chairman, members of the board, just to give you a bit of background on this, this rulemaking has been underway for, approximately 4 years in the informal setting, and what has been submitted to the Office of Administrative Rules represents a really significant leap forward in how the division will be able to regulate mines that are in suspension or have remained inactive for several years. The rule as drafted ensures that the mines in suspension must, among other things, maintain a safe main site and perform the required housekeeping and record-keeping tasks that are required of mines that aren't in suspension. It also provides a date certain that as to when a mine begins its suspension, which has evaded the division in the past. Overall, this rule presents a paradigm shift in how hard rock mines are regulated, and the division believes it is a step in the right direction for the health, safety, and environment of Utah. I do have a few questions that I would like to ask either Paul Baker or Dana Dean, but before, I just want to discuss the comments that were submitted by Ms. Fields on January 22nd, 2020. First and foremost, the division appreciates Ms. Fields' contribution to the rulemaking process. With that said, the division has not directly addressed every single one of her concerns in this immediate rulemaking, but her input has been considered, and as will be noted by Paul Baker, could result in future rulemaking if the board deems it appropriate. So again, while the division has not addressed every concern of hers, the division does agree with Ms. Fields that Ms. Fields' previous testimony that the rule is a step in the right direction. So if I could respond to her comments in just 4 broad categories, and then Paul will follow up with this. First, the division has addressed some of her concerns already. So for example, when Ms. Fields commented that there was no date certain as to when a mine enters suspension, that concern has been addressed by ensuring that a mine has an affirmative obligation to submit documents and other items to the division. And if that omission occurs, the division can deem the mine in suspension. Excuse me. Yeah, can put a date certain on to when the mine is in suspension. Second, the division's goal in writing rules is to not make business decisions for mine operators. The reclamation of a mine is the last step in closing up shop, so these rules ensure that so long as the mine is kept in a safe condition, it may remain in suspension. This does not mean that the mine is unregulated, and most importantly, the mine must keep adequate surety in the event of a forfeiture becomes necessary. Even if the mine is deemed abandoned by other regulatory agencies, the division still holds bonds for those mines that have yet to be reclaimed. And if the private entity is still willing to submit to the jurisdiction of the division will not force the mine to close. Third, the division believes that this rulemaking really does give the division additional tools to address mines that are inactive and not being maintained in a safe condition. So though a discussion of specific mines is outside the scope of this rulemaking, the division believes that with the adoption of this rule, it will be better equipped to deal with problematic mines. And then finally, with respect to Ms. Fields' comments, certain comments she raised were outside of the jurisdiction of the division, and specifically in respect to this idea that a mine can only be deemed in suspension if it's inactive for 2 years. That's set out by statute, and the division and the board does not have any authority to go beyond that 2-year mark. So with that said, that's just some kind of the general response to Ms. Fields' comments. She did help the division identify a clerical error in the rule that was submitted to the Office of Administrative Rules. So I just want to point out this for the board's attention, and then we can discuss how the board should address this in the future or at the end of this hearing. So there's 2 non-substantive changes that the division is recommending at this point. They are both relating to a clerical error. In essence, the rules internally cross-referenced the wrong portion of the rule when it was updated. And those changes could be or are in front of you on your screens now. So it's essentially just clearing up to make sure that with this proposed rule, the internal cross-references are correct. So there's 2 errors. One of them is when Utah Admin Code R647-3-113.10, and the other is in 647.4.117.7.15. So this, I'm not going to read the text of this. I would ask that at the close of this presentation that the division direct the board direct the division to file a non-substantive change with the Office of Administrative Rules prior to filing a notice of effective date with the rules. And the board can rely on this slide and this following slide to note the changes that must occur. If there's any questions about that, I'd be happy to answer them.
Any questions, board members? You feel like you understand what's being requested here? Good, thank you.
All right, so yeah, overall, the division believes that this rule will help the division determine which mines truly are skirting reclamation as opposed to those that are making a calculated business decision to remain unreclaimed. And the rules represent years of effort on behalf of the division and the regulated community and represent a step in the right direction with respect to the mines. So at this point, I would ask that Mr. Paul Baker be sworn as a witness. He'll be giving some testimony today.
Proceed.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Baker, will you just please state your name and title for the record?
My name is Paul Baker. I'm the Minerals Program Manager for the Division of Oil, Gas, and Mining.
Okay, I'm just going to ask you a couple of questions that reflect essentially what I presented to the board, but I'd like to hear it come from the division. So, did you or someone at your direction read and consider Ms. Field's comments?
Yes, I read them.
Okay, and are there any specific examples that you would like to address regarding Ms. Field's comments that demonstrate that some of her concerns have already been addressed?
So, I don't think that the rules necessarily specifically address her comments. However, the division has considered them and considered whether they're appropriate under the Act. And there are a few changes that I think at some point in the future that the division would probably like to have. But at this point, I think it's important that the rules be adopted and that we perhaps address these other issues at some time later. Specifically, the proposed rules for large mines say that the division may require a notice of suspension, and Ms. Fields suggested that the division would, in the small mine rules, it says the division shall demand a notice of suspension. And so she's suggesting that it should be shall demand rather than may require. And I think, like I said, at some point in the future, that would be a good change to have. The second one is Ms. Fields suggested that after the initial approval of a 5-year extension, the division would need to approve subsequent extensions. That is not in the rule. I think it's a good suggestion. I think in both of these cases, it's what the division will do. It will be our practice, but it is not actually in the rules at this point. I would like to see that change at some time in the future.
Okay. And just for the benefit of the board, would these two changes that are reflected on this slide, are those reflective of what you're suggesting in your previous comment?
Yes, that's correct.
Okay. So before we go to the idea of further rulemaking, I do want to just kind of nail down a few topics that I previously discussed. So do you think there is a business decision to be made as to why a mine would be kept in suspension as opposed to reclaimed?
Yes, absolutely. And the division does not have the information to be able to make that kind of decision. My feeling is that if an operator is willing to maintain the site, expend the funds to maintain a site, pay permit fees, have a reclamation surety, if they're keeping in compliance with all of these things, that's their decision to keep that mine open.
Thank you. And is the division prescribed by statute from adopting certain rules such as the suspension period beginning sooner than 2 years?
Yes, that's correct. The Act doesn't say anything about requiring a suspension notice prior to 2 years.
Okay. And does the adoption of these rules present a shift in how the division regulates mines in suspension, and specifically the definition of suspension?
Yes. The main thing is that it gives clarity to what suspension, the terms suspension and shutdown mean. And it gives us the opportunity to require certain actions of an operator when the mines are in those conditions.
Okay, thank you. And under the rules as proposed, are mines required to keep the mine in a safe condition even while in suspension?
Yes, that's correct.
Okay. And at this point, do you have anything further you'd like to say about the potential for further rulemaking, or do you think your previous comment was adequate?
I think my previous comment was adequate. The only thing I would add is, in anticipation of this, the division has already prepared a spreadsheet showing mines that have been in suspension, and we are prepared to proceed with requiring suspension notices and requiring reclamation of those mines that we consider to be shut down.
Thank you. All right. At this point, I just rephrase or reframe the recommendations that the division is asking of the board. First, because there was the discovery of the clerical error in what was in the rules submitted to the Office of Administrative Rules, we'd ask that the board direct the division to file a non-substantive change with the Office of Administrative Rules, and direct the division to do that first, prior to sending the notice of effective date to the Office of Administrative Rules. So, non-substantive change first, and then direct the division to send the notice of effective date prior to March 30th of 2020, which is when the rule would lapse. In front of the
Let's
office.
take that now, if that'd be okay with you.
Yeah.
Board members, the division has asked that the board direct the division, to file a non-substantive change with the Office of Administrative Rules, as Mr. Kessinger just laid out. Do you feel like you understand what is being requested? Then a motion to do that would be in order.
I'll move that the division file a non-substantive change with the OAR, I guess it is.
Is there a second to that? So it's basically, I'm addressing 1 and 2 at this time, or just 1?
I believe your motion was just for number 1.
Okay. Everyone clear on that? Any comments or discussion? Okay, the motion before you then is the board is directing the division to file a non-substantive change with the Office of Administrative Rules. All in favor say aye.
Aye.
Any opposed? Let the record show that was unanimous. Now would you like us to do item number 2?
Yes, please.
Want to discuss that any further?
So item number 2 on this list was the action the division had anticipated taking prior to seeing Ms. Field's comments. Ms. Field's comments actually alerted the division to this clerical error. And so this second item is essentially the capstone on a formal rulemaking. And so if the notice of effective date is not sent to the Office of Administrative Rules, then the rule lapses. And so in order to make this rule effective, that notice needs to be sent to the Office of Administrative Rules.
That we're now open for a motion to accomplish that. Would someone like to make that motion?
Okay.
Can I ask a question first, Mr. Chairman?
Well, we make the motion and have a seconded, and then we'll.
I don't know that I'm prepared to vote until I ask this question.
Oh, well, then let's go ahead.
I'm not sure if 3 addresses my question, Mr. Baker, but how are we going to keep track of the suggestions that you want to incorporate by rule at some point in the future? The 2 that you mentioned, how will that be tracked so that it actually takes place?
I'll answer that, Dana Dean, again. Is this working? If the board directs the division to commence informal rulemaking today, then we would commence that process and get the informal rules group together and begin working on that change now. If the board does not direct us to do that at this time, we will add it to our list of rules that we would like to work on in the future and make sure that it's on a high priority there, and do the informal rulemaking as prioritized with other rulemakings that the division is working on right now.
That's what 3 is.
Yeah, so either direct us to commence that informal rulemaking now, or leave it to us to commence that and come back to the board and ask for the authorization when we're ready. So it's up to the board how important you think those substantive changes are and how quickly you'd like to see those discussed in an informal rulemaking and moved forward.
Thank you for the clarification.
As long as we've gone there, I also have a question pertinent to number 3. Is this specifically dealing with the items that Paul had just discussed? For instance, using shall demand for the notice of suspension subsequent to 5 years, and requiring a notice of suspension and the approval of the division after the 5-year suspension, those 2 items in particular? Or?
Yes, but once an informal rulemaking begins, then a lot of other comments and suggestions could come in and it could morph into something different. Those exact comments could be deemed unnecessary by the informal rules group or the board and the group during the formal rulemaking. So that's what we would start with as a proposal with the informal group, but where it goes from there is up to the group and the board and anyone working on the rule to try to get the best rule in place that we can.
Thanks.
So, Mr. Chairman, I would move second item on the list.
Did y'all hear that? The motion is to move forward with number 2. Is there a second to that motion?
Second.
Any discussion? Seeing none, the motion before you is for the board to direct the division to file a notice of effective date with the Office of Administrative Rules to make this rule effective after the non-substantive change is entered. You understand that? Okay. All in favor say aye.
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 And any opposed? Let the record show that was unanimous. Now, as to the third issue, as I understand it, we have 2 options. One is to begin the rulemaking process by commencing informal rulemaking specific to the substantive changes discussed today. The second would be to just let the division work on this as a priority item as they best can get to it. We're open for discussion on that. Anyone want to comment on what process you'd prefer? Have I stated that fairly? Okay.
The issues and the nuances are fresh in everyone's minds right now. I guess a worry is if we put it on the back burner, do these things fall through the cracks?
I guess my question would be to Dana and Paul, if we did not direct you to address item number 3 today, how would that fall into your schedule for informal rulemaking going forward? I guess the question is, how far down the line would you wait until you went into informal, or would like to wait until you went into informal rulemaking?
I would like to get it addressed quickly, but I think if the board were to direct us to do this, it would be done more quickly.
I understand how much you like coming before the board, Paul. But,
Yes.
but I would tend to agree with the suggestion that we get it done now.
Any further discussion? Okay, a motion is in order then to, as I read the body language, is to commence informal rulemaking specific to the changes discussed today. Is there a motion in that respect?
So moved.
Okay, is there a second?
Second.
Okay, any discussion? The motion before you is to keep this rulemaking moving forward, that it's the desire of the board and a direction to the division to commence informal rulemaking specific to the substantive changes discussed today. All in favor, say aye.
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 Any opposed? Let the record show that that was unanimous. Thank you very much.
Thank you very much.
Okay, we are on docket, or agenda item number 3, docket number 2019-025, cause number 139-169, in the matter of Altamont Energy Operating. And this is this comes before the board because of a bifurcated proceeding so that the main case could be put on, and now we're getting to the bifurcated portion of that. Okay, I'll take appearances of counsel at this time.
Mitch Mayo on behalf of Altamont Energy Operating.
Gordon Rowe from the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Mr. Rowe, welcome. Mr. Mayo, welcome.
Thank you.
Seeing no others, Mr. Mayo, would you begin?
Yeah, absolutely.
And will you make sure the board is clear where we are?
I'm happy to. Chairman, I didn't plan to present any exhibits. There's no new testimony or evidence today necessarily, and I can discuss what has happened. If the board would like, I think I still have my presentation from the last hearing if visual aids are necessary. So just let me know as that goes. Real quickly, Altamont last year came in March and spaced sections 1 through 12 and section 1 of 2 South 1 West and 1 and 12 of 2 South 2 West, essentially 14 sections right in a row for horizontal development. We came back in July and spaced those 14 sections for 2560 section line wells, essentially establishing 6
Drilling unit boundary wells.
Thank you. Drilling unit boundary wells. I apologize. I will get used to that nomenclature at some point. And that was approved by the board at the July hearing. We came back realizing that there were additional sections next door that Altamont didn't realize its ownership share in and traded for remaining acreage, and appeared before the board at the December hearing to essentially create one more drilling unit boundary well just to the west of what had been approved at the July hearing. Council made a mistake and did not send notice to the BIA and BLM. As a saving grace, council also caught that mistake and notified the division ahead of the hearing, and what we agreed to was essentially a notice provision that allowed for the presentation of the evidence and to not disrupt the board's hearing by unnecessarily continuing the entire thing to this hearing. So in December, at the December 11th hearing, Altamont was here, prepared, and presented all of its evidence. The board had granted a continuance of the request limited to the lands that were at issue, the tribal lands that were at issue. This allowed Altamont to submit proper notice to the BLM and the BIA for their approval or comment. January 14th, the BLM responded and said that after consulting with the BIA and with the internal, that they were in a position to support the request. There have been no new filings in this case. At the conclusion of the December 11th hearing, the board said all evidence has been heard, including as to the continued lands, and that it was warranted, and the board granted it, subject to this hearing to decide essentially if anyone had an objection or a concern that we would then hear. There have been no concerns or objections raised, and as I said, the BLM has come out in support of the request. And so what Altamont would suggest is that subject to the division's comments and any questions from the board, that the board grant the full request, and we can get the order in place to make that final.
Okay. Division?
We've reviewed the letter of support from the BLM on behalf of the BIA, and we have no objection to granting the request.
Okay. Do you want no summation? I guess board members, do you understand what's being asked? I want to make sure that I get it clear. So could you state what a motion might look like?
Absolutely. I think from a board's perspective, the motion would be a motion to grant the request for agency action filed by Altamont in this cause as to the continued lands, with recognition that all of the evidence was heard and presented on the record at the December 11th hearing, and all parties have now been given full official notice.
Roe, you good with that?
That sounds great.
Okay. A motion is in order.
So moved.
Is there a second?
Second.
I'm going to, since you understand it, I'm going to go right to the vote. All in favor say aye.
Aye.
Any opposed? Let the record show that the motion as stated by Mr. Mayo has been approved by the board unanimously.
Thank you.
And then do you need to prepare a draft order of that? We would direct you to do that.
You know, actually, 2 days ago, I submitted a draft order and what I styled as an affidavit of counsel, kind of laying out what had occurred between the December hearing and now. That matched the procedure that had occurred in a December hearing with similar facts involving EP Energy. But honestly, it's unless the board has a particular concern one way or the other, it's probably something that Mike and Gordon and I can.
Yeah, and as soon as that's ready, I'll be able to sign that or direct the secretary to help me get that out. Okay.
Thank you. May I interrupt and ask one Altamont-related question?
Yes.
Our spacing order in March was granted, obviously, under the pilot program, and there's a reporting due. As discussed recently, I think, with Mr. Moon, there has yet not been any horizontal drilling. And so, since this is my first horizontal reporting period that would be coming back before the board, no reporting is necessary.
I wouldn't think so.
Okay.
No. Board members, do you feel basically the reporting requirement was on lessons learned?
Yeah, I'm just wondering if to cross that final T is just a simple letter.
I'm happy to do that.
Yeah, just
that way we have a record.
Something in the file.
Yeah, something for the file.
I appreciate it.
Okay. Board members, we can take a break or we can motor on. Let's just keep going, if that's okay. Thank you, Mr. Mayo, Mr. Rowe.
Thank you for your time.
Okay, we are on agenda item number 4, docket number 2019-026, cause number 007-15, in the matter of the division seeking penalties against Spencer K. Barton. I believe this matter is continued from the December board hearing and has been requested, and I think the board has granted a continuance till the February hearing.
Yes, that's correct. We had some issues getting publication in the local newspaper. It was properly submitted, but the paper failed to get it published. So just to make sure we have proper notice in this matter, we've requested and an order has been granted to continue this to February, and we'll be ready to hear the merits.
Okay. Pardon me. It's been requested that we move to agenda item number 6, unless Mr. Baza is here. And agenda item number 6 will be very quick. Mr. Begley, will you assist me on this so I'll make sure I get this right? Agenda item number 6 is docket number 2017-013-A, cause number RONG-2017-01-A, as in alpha. This particular matter is the pooling rulemaking, and we'd invite all parties that are interested in that to come forward at this time. It deals with pooling, and our desire as a board is to restart the informal rulemaking process with the idea that depending on additional testimony input, that we would move to formal rulemaking at our next hearing. And with that, Mr. McDonald, would you please discuss that?
Yes, Mr. Chairman. Fred McDonald on behalf of the Utah Petroleum Association and EP Energy. Certainly that's the way we would like to go with it. The question, I guess, would be is what you're going to proceed with on the formal rulemaking.
Yes.
The Utah Petroleum Association and EP Energy have submitted a revised proposed rule based on what we read the board to direct at the November 25th hearing. The major changes are that UPA and EP have agreed to drop the requirement to make payment up front in full in exchange for adopting the provisions of the standard unmodified current AAPL Form 610 provisions for the remedies. So that the idea would be is that the parties would be put in the same position as if that had been adopted. And so that's the major change that was made. The revised rule, along with those provisions of that Form 610, were submitted to the board's council last week. And that's what we would advocate for.
Okay. So board members, we did receive a comment letter from Mr. Tony Hunter in the last couple of days. I'd like to suggest that we discuss Mr. Hunter's comments during this informal rulemaking period, that we go with the language that has been presented by Mr. McDonald and the Utah Petroleum Association as the draft that will be discussed during the informal rulemaking, under the assumption that that's a highly consensus bill, but not a complete consensus bill. Mr. Begley, do you feel like I've said that correctly?
Yes, Chairman. And the only cleanup would be is just to clarify for the record that the current version that's within formal rulemaking, based on a number of different issues, mainly systematic with the Office of Administrative Rules, just is allowed to lapse. And that will be the formal board action, is just to have that rule lapse.
Okay. Are you clear on that, board members? So the current formal rulemaking will lapse. The language that we will be going forward with during the informal process will be that as presented by the Utah Petroleum Association, and the comments by Mr. Hunter will be addressed during this informal period of time so that everyone has time to examine those and to determine a response. So a motion is in order that we would proceed under this RO&G 2017-01-A for informal rulemaking. All in favor say aye. Just a second. Procedurally, we need a motion. You're right.
Mr. Chairman, can I clarify too that part of that motion should be that you're allowing the other rule to lapse, as
Yes.
Mr. Begley pointed out.
So why don't we make sure that we got this right? Could Mr. Begley or Mr. McDonald or the division, I'm sorry, division, I didn't give you a chance to respond to this. My apologies.
I think we agree with everything that's been stated. I'll give a shot at one of the motions I think the board should make, which is to not send the notice of effective date to the Office of Administrative Rules, which would effectively allow the rule to lapse.
Okay. Why don't we do that as a separate motion? Let's do that now. Okay? Everyone understand the motion? Would someone be willing to make that?
I move that we not send an effective date to the Office of Administrative Rules, which effectively allows the formal rules to lapse.
Is there a second to that? There is a second? Okay.
Second.
All in favor say aye.
Aye.
Any opposed? Let the record show that was unanimous. Okay, thank you, Mr. Kessinger. Okay, now we're down to the new language. Mr. McDonald or Mr. Kessinger, would you be willing to formulate a motion?
I would defer to Mr. McDonald.
Mr. Begley.
I believe the motion, Mr. Chairman, would be is that the board will again commence informal rulemaking to consider the proposal submitted by the UPA and EP Energy to Board's Council last week, with consideration of Mr. Hunter's comments, with the idea of going to formal rulemaking at the February hearing.
Okay. Please don't restate that. Just say, I make a motion that we do that.
Make the motion what he said.
Thank you. Is there a second to that?
Second.
Okay, any discussion? You've heard the motion. All in favor say aye.
Aye.
Any opposed? Let the record show that that was unanimous. Okay, anything else we need to do on agenda item number A? Okay, let me then, okay, we good on that? Please stay, Mr. McDonald, if you would. We are now on, we're still on agenda item number 6, but we are in we're going to the B docket, Julianne, and so I'm not completely sure how we want to do that, but it's a different docket. That's the B. But it's the I'm going to ask the board's counsel to assist me again on this. We are going to then agenda item number 7. It was and let me read the docket first. Docket number 2017-013, cause number RONG-2017-01. It's the desire of the board that we separate and create a new sub-docket for 2 other sets of rulemaking. At the time it becomes formal rulemaking, it could be directed to be a sub-item B and a sub-item C. B would involve the draft language presented by the Utah Petroleum Association dealing with operatorship, and the C sub-docket would be on the matters dealing with the division's language on horizontal drilling. So at this time, we are on the B component, dealing with operatorship. And the idea is that, board members, we would start the informal process, and the language that we would use would be the language submitted by the Utah Petroleum Association for that discussion, with the idea that we would go to formal rulemaking at the February hearing. Now, first of all, Mr. McDonald, would you comment on that, and then division, and then we'll go to the board questions.
The proposal that was made was, we had a discussion earlier this month with the division about some of the language. The division was going to look at it again and get back to us with any additional comments. So I'm not sure if, you know, there'll be further revisions for that, if that's part of this informal rulemaking. But, you know, I wouldn't say that it's in a form right now that we would submit for consideration for formal rulemaking. It's still in the informal process. Mr. Kessinger or Mr. Rowe, you can correct me if I'm wrong on that.
I would agree with Mr. McDonald's characterization. I think there's been a lot of positive developments in terms of operatorship and horizontal rulemaking. I think we had a very productive meeting with several of the board members there as well. However, the division's still internally drafting horizontal rule language.
We're just on the operatorship now.
Excuse me, okay, just operatorship. The division's still reviewing the operatorship language, and in terms of moving forward with formal rulemaking in February, it might be a bit overzealous, but I know that we're trying to stick to a tight schedule, so we'll do our best to.
Just know that we'd like to do that in February, if at all possible.
And
Yes,
Mr. Chairman,
okay.
if I could add one more thing, the draft that was submitted for discussion purposes, there was one modification to that, which I will be happy to submit so that everybody has the most current version. It was to add a clarification point with respect to the position that an operator who is designated as the operator could request that APDs that have been submitted but not been drilled be revoked. And that was a clarification that
Yes.
was
Okay,
as
would
to
you
wells
please
that
submit
weren't
that?
drilled yet. Yes.
Yes. Okay. We're off the record. We're back on the record. By what you're submitting to us, Mr. McDonald, and we're looking for a redlined version so that we can see what the original language was and what's being proposed for change.
Certainly.
So with that, board members, so we're talking about the subdocket B would be to move forward on operatorship rulemaking in the informal part of our rulemaking process. Is that the best way to say that? I don't think so. So some help me here restate this. We're going to start with informal rulemaking with the amended Utah Petroleum Association language, with the desire that we would address this and go to formal rulemaking in February. I've got a couple of.
So I have a question. When do we need to have the document that's going to be submitted to start formal rulemaking in February? I think that's a question for Tom Kessinger.
Typically, filing deadlines, I believe, would allow for submission up to the 10th of February. However, there might be special cause in rulemaking matters to use a different date. I'll have to double check on that, and I can report back to you by the end of today's.
Your client's walking up to talk to you.
Okay, and so just a point of clarification, the board is only seeking the draft that the board would then submit to the Office of Administrative Rules to commence formal rulemaking, not to actually send that draft by the 10th.
No, we're just starting the informal process. So the February would be then to get all of the input and to look at the possibility of going to formal rulemaking at the February hearing, and it would be on that date that we would have the draft that we would send to the office that you just mentioned. Are we clear on that? So, Ms. Davis.
just to clarify then, so Mr. McDonald is going to submit a red line version of the UPA operatorship rulemaking. That,
As amended.
as amended, yes, that needs to be submitted by February 10th, correct?
I believe that is the date. However, given that this is a rulemaking matter, there may be cause to extend that deadline further, but I think the 10th would be the general filing deadline before the board.
So that in February, we can move to formal rulemaking, correct?
So long as there's a draft prepared, correct?
That was my clarification.
Okay. Board, Mr. Moon.
So this draft, you know, I saw it because I came to that meeting, but has this draft been put out there for the general public? I'm kind of feeling like we're trying to set up for formal rulemaking in February when we, you know, haven't even put it out there. So that's my question. Doesn't there need to be just that public process of the informal rulemaking before we're indicating we want to have formal rulemaking in February?
I would agree with you, Mr. Moon. That was the point we were trying to make. It was a starting point for discussion. We were waiting for more feedback from the division, and then the division was going to seek whatever additional input to it.
So I agree. So that public input needs to come to the division. So division, what is your plans as far as putting this out as, hey, here's what we have so far?
Can I say that when we've done informal rulemaking in the past, we've generally done it with a select group of stakeholders. It hasn't been a public affair. I mean, that's why it's called informal rulemaking. The only time the general public, meaning anyone who is monitoring the state bulletin, would see it is when we commence the formal rulemaking process. So I think what we would try to do is, as quickly as possible, get our comments back to Mr. McDonald and the Petroleum Association. But I think we would probably, if this is desirable, include some additional stakeholders who we haven't contacted yet, very frankly. And that would help, because when it comes in front of the board, you don't want a lot of controversy and conflict. Hopefully everybody is agreeable to at least the form and most of the content of the rule.
Yeah, we're trying to do it differently this time, so all of that doesn't come before the board. And so so it's the ball is in your court, and so just encourage that happen, that reaching out, whatever it takes to listen. And
So do you feel like we're ready for a motion? So the motion would be to move sub-docket B on operatorship to informal rulemaking. Someone like to make that motion?
yes,
Okay.
so moved.
And then is there a second?
I'll second that.
So the motion before you is to move sub-docket B on operatorship to informal rulemaking. Any discussion? All in favor say aye.
Aye.
Any opposed? Let the record show that was unanimous. Now we're going to sub-docket C on horizontal rulemaking. We're basically doing the same thing, board members, and that is starting the board-requested informal process for horizontal drilling rules. We'll go to you, Mr. McDonald, first, and then the division.
At this point, there has been some white paper points discussed that the division had. There's been further discussions with that, but nothing formally in a rule has been drafted yet. I understand the division's going to do that, and UPA has offered to assist with that draft, but it's not in the same position as the operatorship rules are.
Okay. Well, we would like to start the informal process. Whether that on subdocket C on horizontal drilling, whether that goes to formal in February is still an open issue. But we would like to go to formal rulemaking as soon as possible. And so the board directs or encourages you to get to that point and to prioritize it to the point you can. So, board members, any questions? So the motion that would be to the board to direct the division to go to informal rulemaking on subdocket C regarding horizontal drilling so that they can come up with language that they could use to go to formal rulemaking. Is that clear? A motion would be in order. And you can do that by saying so moved.
So moved.
Is there a second? Motion's been seconded. Any discussion? All in favor say aye.
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 Any opposed? Let the record show that that is unanimous. And I believe that takes care of agenda items number 6 and 7. Am I clear on that? Okay, then we are, bear with me a second. We are on agenda item number 5, which we held off to until we could get the director to be here. What I'd like to suggest we do with agenda item number 5 is to receive opening statements and procedural questions. And then we're going to plan on breaking for lunch at about noon. So let's see how far we can get. That's also a natural breaking point in the discussions. I'll first read this docket into the record. This is agenda item number 5, docket number 2019-027. Cause number 194-03, in the matter of the request for agency action of Wesco Operating. And please note that we have received a number of comment letters, and we'd like to discuss those a little bit at the beginning. I'll take appearances of counsel.
Fred McDonald and McDonald and Miller on behalf of Wesco Operating, Inc.
And, okay, and for the division.
Thomas Kessinger, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Is there any others?
Gordon Rowe for, with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Thank you. Others? Seeing none, then let's do this. Procedurally, we have received in evidence a number of exhibits and documents. There appears to be a couple of new ones, and there's also a supplement to Exhibit Z. We will admit those at the end of the proceeding, if that would be okay. And with that, Mr. McDonald, I'm assuming you're going to take the initial discussion.
I will, Mr. Chairman.
Okay, please proceed.
As the board is aware, this
One
is...
thing first, do you have witnesses to be
I
sworn?
do. That's what I was going to take care of.
Okay, let's do that at this time.
With me today is Mr. Tom Kirkwood, the petroleum engineer for Wesco Operating, Inc. He was recognized by the board as an expert in petroleum engineering in the matter that was heard in December, as well as other matters, and I ask that he be sworn in at this time.
Proceed.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Are there any witnesses with the division that would need to be sworn?
There are. I plan on calling Director Baza to testify.
Let's have him sworn at this time.
You raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, to you, Mr. McDonald.
Thank you, Mr. Chairman. As the board is aware, this is a continuance of the matter that was heard in December regarding the flaring of gas at the Blue Hills gas plant outside of Moab. At the end of that hearing, the board directed Wesco to prepare and provide options in lieu of flaring at the plant and the economic impacts of that, and directed that Wesco come back today and provide that information and testimony. And that is why Mr. Kirkwood is here today. Since that time, there's been a number of events that have occurred. There has been a Public Service Commission hearing in front of the board of that commission, where the Public Utilities Division has requested the decommissioning of the pipeline at issue here. There has not been a ruling to that. Mr. Kessinger did a great job in his memorandum outlining the status of that. In addition, as you are aware, the pipeline operator of record is Pacific Mining, who is in Chapter 7 bankruptcy, and a trustee was appointed. The trustee is undertaking various discovery measures to determine if other entities should be brought into the bankruptcy, which will impact the ownership of the pipeline, in addition to the operatorship of that. And there are a lot of consequences that may develop out of that, but that is ongoing as well. And again, Mr. Kessinger outlined that in his memorandum that he filed on Monday. The notice of this hearing today was published in the Salt Lake Tribune and the Deseret News on January 5th, and it was in the Moab Independent Times, or Times Independent, on January 9th. At that time, the responses that have been filed, the division filed its memorandum on Monday, which was out of time, but which was authorized by Wesco, that was unopposed to do that. In addition, on Monday afternoon, we received an email from Mr. Trepanier, I believe is how you pronounce his name, indicating that he was objecting to the request, but with no detail as to the basis of the objection or the any exhibits. And as far as I know, that's the only thing we have received. We would object to his participation as a party to these proceedings, but we do not have an objection to him making a statement to the board at the end of the proceedings if he wants to make that statement. With that, we'll commence the examination of Mr. Kirkwood.
Proceed.
Just a quick question. In the December 30th filing, it labels Thomas as Kirkland, not Kirkwood.
Then that's just a typo. It's Kirkwood.
Okay. That's Petitioner's Exhibit 4. It says Kirkland.
Yeah, it's Kirkwood. I'm sorry. It's just a typo. Mr. Kirkwood, please state your name and address for the record.
Tom Kirkwood, engineer at Wesco Operating, address 120 South Durbin, Casper, Wyoming 82604.
And you are the petroleum engineer for Wesco?
Correct.
Okay. I'm going to show you what has been marked as Exhibit 4 for purposes of this cause. Do you recognize this document?
Yes.
Was it prepared by you?
Yes.
And this document was prepared in response to the board's request to outline various options in lieu of flaring and economics. Is that correct?
Yes.
All right. Would you walk the board through each option? Let's start with number 1, the trucking of compressed natural gas.
I started out with looking at trucking off the compressed natural gas. In order to do this, we'd have to construct some load-out stations to load the compressed natural gas and install an additional compressor to bring it up to the approximate 3,000 pounds required for trucking. Then you'd also need an offload spot that's got a pressure reduction unit that would allow the gas to be safely put back into an existing line after being transported over the road.
And what would the costs of that option be to Wesco?
There would be a cost of about $250,000 for upgrades at the Blue Hills gas plant and $650,000 for the offload equipment. You'd also see an increase in monthly costs for the additional compression and for the trucking required to truck the natural gas over to the natural gas line.
And the economics of that option are shown in the table at the end of Exhibit 4, is that correct, under Option 1?
Yes.
Do you have Exhibit 4 in electronic formats?
I did not bring it, Mr. Chairman, just because it was all paper.
It is available on the board's website.
I'm just wondering if we could put it on the screen for the audience or for the...
I could do my best to present it to the board and to the public. Just one moment.
Let's just take
May
a
want the
second
table
here.
at the end, Tom. Thomas, the table at the end is probably the best.
Is that appropriate?
If you
prior
could just
page.
enlarge it a little bit.
Then one more page up. There you go.
Thank you. I think that'll be helpful for everyone. Okay, please proceed and apologize for the interference.
Okay, Mr. Kirkwood, turning to the second option, it's use of gas for power sales.
Yeah, this one was basically to use the gas to generate power to sell the power to the power company. This was looked at as two different options, either using the residual gas at the tailgate of the plant for, and then still stripping the NGLs, or pulling out the, decommissioning the plant and just putting it all towards power. To do that, you're going to need six 550 horsepower generators to burn approximately 400 MCF a day at the tailgate of the plant, and then you're going to have to construct which requires some minor fittings and electronic stuff to be added to the plant, as well as constructing a three-phase power line to the nearest three-phase power. There are overhead power lines, high voltage overhead power lines that run directly over or directly by our plant. However, we have tried to pull power off of them, and it's very, very difficult. And so it's easier to just run roughly 7 miles of new power line over to power lines over by the airport to the east. And the cost for that was roughly $1.2 million for the power and $100,000 for the upgrades to the plant. That would also increase your plant operations by about $81,000 for the generator rental and additional maintenance required for it. In that, you're going to bring net about $58,000, $59,000 in cost of product. $45,000 from electric and $12,000 from NGLs.
Mr. McDonald, can I, at the end of this option, I sense that there are board members who would like to ask questions rather than wait to the end. Would that be disruptive?
Oh, that's fine, Mr. Chairman.
Okay, so continue on the gas to line power.
Okay, Mr. Kirkwood, you provide two different options under this. Could you explain the difference between the options?
So the first option is taking the residue gas at the end of the plant and generating power with that. The second option is just taking the inlet stream of gas and then decommissioning the plant and then producing power for the life that gas is needed to be flared for the rest of the well's life. And then, so for option 2, you had additional facility upgrades. You'd need some drying units and some small gas processing units to get your gas to quality for all the generation. And then you still have the three-phase power lines, and then you've got gas plant decommission cost for a total cost of $2.4 million.
And those economics are reflected in Table 2 of the latter part of Exhibit 4, is that correct?
Correct.
All right, Mr. Chairman, do you want to ask questions about that option?
Just, yes, there was a question. Mr. Brown.
Are there regulatory hurdles or obstacles to put power on the grid?
We've looked at it as far, generally it's dealing with your power company, and they can be, they generally don't mind taking it. It's at a significantly less cost than what you pay for into your house, but and it does require quite a bit of fail-safe, so you don't send them bad power. There would be permit requirements for the gas generating engines, for the gas-fired engines.
Had some experience with cogen plants in Pennsylvania.
Did that deal with quality, electric quality?
No, I don't think so. I'm just wondering, but it doesn't sound like it's that big of a hurdle here.
Well, I don't think it's that large. I think it probably has to do with the volume of electricity that's going to be
Quantity.
yeah, the amount that's going back. They do require like a bunch of load calculations that Rocky Mountain Power, whoever the power company is down there, that would have to be done to ensure, and then they might require upgrades to their system as well.
Okay, thank you. Was there other questions? Let's proceed.
Okay, Mr. Kirkwood, now turning your attention to option number 3, which is use of gas for power generation for computer processing. And as a preface to that, if the board recalls, last year you received a presentation during an informal hearing of the use of this for Bitcoin purposes by Mr. Cavness, I believe, from Denver. Mr. Kirkwood, please address this option.
We've looked at this with a number of different companies. Some of it do it for Bitcoin mining, some of it do it for cloud space storage. All of them would only take the gas. They need to, for it to be economic, they want to have the inlet stream and not the outlet stream for it. So you would your cost would include decommissioning the plant, and then some facility upgrades for some minor gas processing, so the generators run properly and electrical grid electricity can be run. And then your monthly cost would be your generator operations and your generator rentals for a total of about $136,000. Most of the companies will provide the Bitcoin mining processors, and with a 18 to 24 month contract, and after they make 2 times their investment, then you can get backed in for some of the proceeds from the Bitcoin. We've looked at quite a few different people. The Bitcoin doesn't generally cover the cost of the generator's maintenance, but it is an option for if you can't get onto the grid with your power.
Is there a certain minimum amount of gas that's required for any of these operators for that option?
They do. I mean, they all definitely do want the. Right now, we have about roughly 400 or so MCF coming into the plant, and they do want to have the full inlet stream. If you go to the tailgate stream, none of them are very excited about it, and it's out of a lot of their areas. So then we do a lot of the maintenance, and they'll do the computer processing, the remote work with the computers, but most of the field stuff would have to be done by Wesco staff or a consultant.
Is there a concern, though, about the minimal amount of gas that they would require for that, and Wesco's ability to meet that with the current rates?
Correct. That would be a concern. If you dropped your gas down a set rate, there might be some penalties as far as their contract would go. There's a lot of different companies out there that do it, and finding the best one that fits in the market would be tough. And there's not a whole lot of people doing it. It's still very, very early on in the phase of operations. I've talked to a couple people that have a couple of operations currently in use, but it's not incredibly widespread yet.
And in Exhibit 4, what I'm trying to get at is you mentioned that they would require at least 300 MCF per day. Is that right?
Correct. That's the numbers that were thrown around early on.
The other point I'd like to make is a legal point with that. This new option presents all kinds of legal issues with respect to how you pay royalty, what the valuation would be on that. There's all kinds of uncertainties with this option. So while it's an encouraging option to deal with flaring, there's a number of legal issues that are wide open on this. And finally, in Table 3, this is the economics that you've calculated associated with this option at the end of the Exhibit 4. Is that correct?
Correct.
Okay. Turning to Exhibit 4. Oh, want to ask you one other question with the Bitcoin. You say that they take it from the feed line, so the NGLs don't get stripped out?
They would not in this case. They need the more gas to get the volume for them to be operating in the area.
Okay. All right. Option 4 was to remove the NGLs at the plant while the flare is residual. This is the option that you're requesting. Is that correct?
Correct.
Okay. Could you talk a little bit about the flare again at the plant? How clean a burn is it? How efficient is the burn?
It is an engineered design flare. In the specs, it says that it can burn, should be able to burn the gas at very high quality. Stripping the NGLs out also increases your. It's going to be a lot cleaner burn than you would if you were to do it without the NGLs, and a lot of the heaviers in there will make a more dirty flare than with the high ends out of it.
Okay. Table 4 then at the end of the exhibit shows the economics associated with this option?
Correct.
Okay. We're going to skip over your fifth one, which is normal pipeline operations, because that would only be if the pipeline's reopened. Is that correct?
Correct.
Okay. And that's the problem right now, is it's not open. Let's go to option number 6, which is the installation of a new sales line. Please address to the board what that option entails.
This would be us twinning the existing shut-in line with a new line. I estimate the cost at $40 a foot to install a new line, plus a $500,000 tap charge to tie into the interstate pipeline. And that'll get you the tie-in and the metering that's required on that side. Aside from that, the operations and revenue are very similar to the way we're running now. You just have the capital costs of the pipeline to be installed.
Okay, and the economics associated with that are shown in Table 6 at the end of Exhibit 4. Is that correct?
Correct.
Okay, and finally, you have the last option is to flare at the well sites. Could you please address that?
This would be just if we were to just flare at the well sites and get approval for flaring at the well instead of at the plant. And that would be include the decommission of the plant, but would be the monthly savings of not having to operate the plant, but you would be losing gas and NGL revenue because you wouldn't be able to sell it.
And again, the flares at the wells would be not as efficient or a dirtier flare than the one that's occurring at the plant?
Correct, yes, they would. And in the field, we do below ground level flares to help with the dark skies and that's over this area. So they're not as good of a flare, and then you're going to have wetter gas, which causes to more of a dark smoke or a dirtier burn.
And with the current 18 wells, that would mean potentially 18 different flares throughout the field.
Correct.
I'd like to point out, legally under the regulations, so long as those wells were producing gas at under 1,800 MCF per month, they could legally do that right now under the regulations. It's only if they're over that amount that it would require board approval. The economics for that option are shown in Table 7 at the end of Exhibit 4. Is that correct?
Correct.
Can I just ask a question on that? I see those under the profit loss, The far right column, it shows those as a positive number.
Correct, because right now we operate, the plant operates with the low volume throughput. Right now it operates at a loss. And so you would be saving your operating costs on to operate your plant. So I put that in there as
As a positive number.
positive number, correct.
Okay. Is that understood, board members? Okay. Proceed.
All right, thank you, Mr. Chairman. Okay, Mr. Kirkwood, would you please address for the board the update on the current rates, the gas that's being flared and the well rates and et cetera since the last hearing?
Correct. So in September, our plant flare was 221 MCF per day. October, we were 159 MCF a day. November, we were 123. In December, we were 147. The two wells, when allocated back, that was 87 MCF in September for the 36-1 and 61 for the 12-1. For October, it was 65 for the 36-1 and 44 for the 12-1. And for November, it's been 52 MCF a day for the 36-1 and 36 MCF for the 12-1. In December, it's 50 MCF for the 36-1 and 48 for the 12-1.
So right now, those wells are producing gas that would be under the regulatory limit if you were to flare at the site. Is that correct?
That's allocated back from the plant.
Right, right. So what is the current rates that's being flared at the plant?
So yeah, currently, well, December we flared 147 MCF per day, and then November is 123.
Okay, one of the issues here was also the question, what would be the impact on the oil economics if you added those in on these various options? Could you kind of address that?
Yes, so for December, the 3 wells would have been, if we were to flare at the wells, 3 wells would have been over the 1,800 MCF. That'd be the 36-1, which produced roughly 5,150 barrels of oil and 4,600 MCF of gas. The 12-1 made around 1,550 oil and then 4,400 MCF of gas, and the 13-1 made a little over 1,000 barrels of oil and 2,300 MCF of gas. If you were to take a linear relation to drop those down to the 1,800 MCF per month, you're going to lose roughly 4,347 barrels per month, or 137 barrels of oil per day and then at $54 oil, that's roughly $6,400 a day in product that would be lost due to choking back, slowing down those 3 wells to get them to the 60 MCF per day at the well.
Can you address, go ahead, Mr. Chairman, I'm sorry. Okay. Could you address, let's go into a little bit more about the option, the division raised as an option in their memorandum about curtailing production from these wells. Can you address kind of the risks that are associated with that if you were to curtail the oil production to prevent the flaring or get it down to a limit?
There is the risk that one of the main risks that we see down there is salts, salts falling out, salt creep. The division's memo brought up a lot of them as well. You also have a lot of these wells have a set amount of life to them, and if you start lowering your production and you have a mechanical well issue, you've lost the reserves that you would have had if you had some sort of wellbore failure associated to that.
So you really don't know or could quantify the impact if you shut in and there's a risk that the well would not produce as good as it would otherwise?
Correct, yes, there is.
Right. One of the questions that was brought up at the December hearing was what jurisdiction or regulatory requirements does the Division of Air Quality impose? Could you kind of address that? You said that you would look at your permit, and what's the situation with that agency?
Currently, there was no notification requirement for flaring at the plant. However, we did provide them notification of the flaring and have not received any response from them about it.
But you did provide them the courtesy notice of the fact that you were flaring at the plant.
Correct.
Right. Going to the economics of the plant, you look at these tables and it looks like the plant is currently operating at a loss. You have to deal with the gas anyways, but can you explain why decommissioning the plant, and in other words, why do you still need the plant if you're operating at loss is kind of the question.
The plan is not only an asset to us, but it allows additional development for our west fertilizer area, which is currently under an EA for an additional 15 locations with up to 45 wells, as well as third parties. We have had outfit was supposed to drill a well this year and has pushed it back a year up north of our plant that has been interested in running gas through our plant system. It's one of the main gas processing plants that's in this area that would have the ability to take third party and allow for future development in the King Creek unit for gas processing.
And that West Fertilizer area, you say it's up to 45 wells. That's currently on suspension status because of environmental studies that have been ongoing for over 5 years. Is that correct?
Correct. Yep. It was submitted by our previous operator in around 2014-15 range.
And once that's lifted and your ability to drill, you'll need to deal with the gas that's generated from those wells.
Correct.
Right. Okay, Mr. Kirkwood, based on your economic analysis, have you reached a conclusion in your expert opinion as to which option is the best, both from an economic, technical, and safety measure?
I feel that the best option is to continue to produce as we are, flaring at the stripping out NGLs and flaring at the gas plant.
Also, I wanted to ask you, the request just says until the pipeline is back in operation. That's kind of open-ended. Is Wesco willing to limit that to a 1-year time, or if the pipeline is before that to that time?
Correct. Yep. Putting some time and some additional updates to the board on a 6-month or whatever, with just to kind of keep you guys in the loop as to where things are sitting.
Finally, could you address what are the efforts that Wesco has undertaken, to get the pipeline back in operation as much as it's within your power?
We have had conversations with them about taking over the line. We've also heard of a potential third party may be interested in buying it, but all this is very dependent upon the bankruptcy proceeding for Pacific and as to what can and can't be done.
So currently, you did have an offer with the quote-unquote record owners about purchasing the line from the plant to the Northwest Pipeline. Is that correct?
Correct.
Okay. So Wesco is taking every effort that's within its power to try and get the line back open.
Yes.
And obviously, it's to your economic benefit to have the pipeline open.
Correct.
Okay. Mr. Chairman, that concludes my examination. Mr. Kirkwood.
Okay, I think this is a logical place to take a break. When we do come back, board members, be aware that I asked Board Member Davis to look at this and to give us a more detailed analysis. And then we're also asking the division to talk to us a little bit about the Public Service Commission process. We had the potential for a conflict between our board and the Public Service Commission. What we directed council to do was to make sure that the Public Service Commission was aware of our concerns, not necessarily that we had a recommendation. And Mr. Kessinger, I believe, did that. But whatever it is, the current status of that, we don't have the jurisdiction to direct them or be in conflict with them. I want to make sure that we're clear on the record that we're not in conflict with the PSC. We just wanted to make sure that they were making as informed a decision as possible. So with that, you think you know where we're going to take a break for lunch, and we'll be back at 1 p.m. Thank you very much.
Mic test, testing 1 2, testing 1 2. Microphone check, testing 1 2.
We're going to start in about 30 seconds. Council, are you ready? Reporter, technical. Okay, we're back on the record. Mr. McDonald.
Thank you, Mr. Chairman. Just the housekeeping that I would move for admission of Exhibit 4 and the supplement to Exhibit Z.
Vision.
No objections.
Board members? It'll be so admitted.
Thank you. That concludes our presentation in chief. I'd like to reserve the opportunity for rebuttal and closing remarks.
Thank you.
Mr. Chairman, thank you.
Now, what stage are we in? Are you going to be cross-examining the witness, or is this your part of the case, just to make sure procedurally?
At this point, I believe we're in the cross-examination of Mr. Kirkwood.
Okay.
And then I would like for the division to have the opportunity to present a very brief case in chief, but we'll begin with cross-examination.
Okay, thank you.
But before we get to that, there's just one procedural note I want to make, was that Mr. Kirkwood was qualified as an expert witness in the previous hearing, and the division would not object to him testifying as an expert in this hearing either.
Thank you.
So, Mr. Kirkwood, just a few questions. When you're discussing curtailment, just generally as a concept, where are you drawing knowledge from in that realm? Is it just, where are you basing your assumptions?
With regard to the wells, or with regard to?
With regard to the wells, and maybe, with the wells specific to this hearing, but also you're talking about curtailment kind of in the field generally. So I just want to know what information you're basing your assumptions on.
So a lot of it's been just some general practices, as well as reviewing some old older wells, and some previous data associated to them.
So there are wells that you can look to in this field, or maybe proximate to it, that have been curtailed or shut in, and then it resulted in reservoir damage.
Well, I've seen cases where after being long periods of shutdown, the production has died off. Yes.
Okay, and specific in this field?
Correct.
Okay. And then is there any literature you're pulling your assumptions from, or is it just general knowledge as a petroleum engineer?
Mainly general knowledge, also reviewing some of the older hearing documents and stuff of that nature too.
Hearings before this board?
Previous from Fidelity.
Okay. In terms of, so going back to your list of options, option 2 being turning the gas into electricity, essentially. Did you look to see if there would be additional permitting required by the DEQ?
I did not look into it, but I know that our current permit only allows for a certain number of generators. So I would very much assume that additional stuff would be required.
Okay, so in addition to potentially some electricity regulatory hurdles, there would be permitting hurdles in front of the Department of Environmental Quality?
Correct.
Is a general assumption, okay. And then going to, sorry to jump around, but I was just trying to collect all my questions here at the end of your testimony. So as of December, there was 147 MCF being flared per day at the plant.
Correct.
And in November, it was 123 MCF per day.
Correct.
And you had described kind of a general trending downward of those numbers, but then there's this increase from November to December. And can you speak to that?
Not overly. Some wells start make a little bit more gas different months. Might have some downtime associated with the well, short downtime.
So there could be some operational things that Wesco did that made gas less prevalent in November as compared to December?
Correct.
Okay. And generally, do you think it would continue to trend down if no further wells were drilled? Or are we going to expect approximately between 100 150 MCF per day?
I would say you could expect that. There is some oddities that come up as wells, particularly like the 12 one's a good example. Most of our wells have about a 500 GOR on it. That one has got 2,000 plus, and it didn't used to. So just as time goes by, you start producing more gas on some wells than you do on other wells.
And forgive my lack of experience, could you define what GOR is?
A gas oil ratio.
Okay. I think that's all the questions I have. I am going to allow my co-counsel to ask just a few questions.
Proceed.
Thank you. I have a few brief questions relating to the the EA and for the West Fertilizer wells. You mentioned that the EA's kind of been stalled for the last 4 or 5 years, but the EA calls for up to 45 new wells. Is that correct?
Correct. It's 15 pads with 3 wells per pad.
Okay, and I know that could you speak to when that EA would be granted? I imagine not, but
I would say it's soon, hopefully sooner more than later. Last communication we had with the BLM, there was a couple of ARC survey additional things that needed to be corrected, and then it'll be put through to be for start final processing on it. So I would hope it, it's coming up not in the in the year type range. I would imagine.
Okay,
But
and
it's really wide open on timing when it comes to a lot of that stuff.
I understand those can take a long time, but once a record of decision or the final disposition of that EA is issued, what would the timeline look like for Westco to bring wells into production?
I would say our current union obligations are 2 wells per year. I would say upon approval, we'd be minimum of 2 wells per year over there. Could be more, depending upon how the wells turn out. But right now, that would be what I would say.
Okay. So the development of this 45 well portfolio would take place over a number of years.
Correct. Yes.
Okay. And then the question stemming from that is what are the plans for the gas coming off of those wells as you produce them?
It would flow. Well, currently would flow to the Blue Hills gas plant for processing.
And you would propose? Do you think that bringing on these new wells would result in flaring in excess of the allowances requested by Westco in this matter?
I would think at that time it would. I would truly hope that the matter with the flow line would be solved by that point. I mean, we're talking a year plus down the road.
Okay, and so Wesco's plans are to continue to flare, and if flaring was required to go in excess of the allowance requested in this matter, would you come back to the board seeking additional flaring?
Correct.
Okay, and I think that's all the questions I have at this time.
Thank you. Any recross?
Just a point of clarification on Mr. Rowe's question about the EA, if a record of decision was issued, that's also subject to any appeals.
Okay, and we're now to the division.
Okay, so I'll just plug this in. We have a brief case in chief that we'd like to present. I will say that at the outset that the division supports the relief requested by Wesco in their RAA, specifically limiting flaring to 400 MCF per day. And the purpose of this case in chief is really just to explain the exhibit that was submitted concurrent with my memoranda on Monday. Before we get to that, I just want to say, like all cases before the board with respect to oil and gas, the board is asked to strike a delicate balance between the right to drill and produce oil, efficient recovery of that resource, and the prevention of waste. And this case is no different. So ultimately, the division concludes that in this case, based on these facts, that on balance, suspending the flaring rule to allow for the continued production of oil will strike that balance that the board needs to take. So with that, I'll move to my examination of Mr. Baza. Mr. Baza, would you please state your name and title for the record?
My name is John Baza. I'm the director of the Division of Oil, Gas, and Mining.
All right. And by virtue of your knowledge, by virtue of being appointed director of this agency, are you imputed with being knowledgeable in the extraction of oil, gas, and minerals?
I would assume so, yes.
Okay, thank you. And do you have any degrees or educational experience that are germane to petroleum engineering?
I have both a Bachelor of Science and a Master of Science degree in petroleum engineering from Stanford University.
Thank you. And prior to working for the division, do you have an approximate number of years that you worked for the industry generally?
I worked for the industry in a couple of different time periods, along with similarities to the division, but cumulatively, I probably have about 7 years of experience in the private sector with Phillips Petroleum Company, Amoco Production Company, Flying J, and TerraTech Resources.
Thank you. If there are no objections, I would move for Mr. Baza to be qualified as an expert in petroleum engineering.
Any objections, board members? No, I think it's a heartfelt yes.
Thank you.
Oh, Mr. McDonald, any objections?
I fully
No,
recognize.
your objection is noted.
Objection to the fact I wasn't asked. No.
Yeah, sorry about that
I
one.
fully recognize Mr. Baza's expertise.
Thank you.
Okay, thank you. So, Mr. Baza, I'd like to turn your attention to the exhibit on the screen before you. Do you recognize this exhibit?
Yes, I do.
And was it prepared by you or under your direction and or supervision?
Under my direction, I had our staff, petroleum engineering group, look at this and develop some language for the memo.
Okay. And can you just briefly explain the purpose of the exhibit, or perhaps what question the division was trying to answer when preparing this memorandum?
We were trying to address the question of, would damage to the resource occur if we either curtailed or shut in the gas plant, and basically pushing that restriction back to the individual wells.
And did you ultimately conclude that the risk presented by shutting in or curtailing wells is uncertain?
It is very uncertain and would require a lot more information than what the division currently has at its disposal.
Okay, and I believe Mr. Kirkwood addressed some of the variables that make this question so difficult to answer, but are there any other variables that make answering this question difficult?
I think some of the variables are that even if we were to ask the operator to provide, substantial technical evidence, there would be a cost to that. There would probably be numerous tests that would have to be run. There would be reservoir engineering models that would have to be created just to address that single question of what it would take to restrict production. And I think the operator is well knowledgeable about the field and what it takes to produce it and what they can get out of the field over time. But I doubt they've asked the question themselves, what would happen to the reservoir if we restricted production?
Okay. And again, on balance, did you conclude that the risk of harm to the reservoir warrants suspension of the flaring rule in this case?
There's a good likelihood that there would be damage to the reservoir, although we can't quantify it or even analyze it at this point, but there's a good likelihood, and the probability of that risk probably outweighs the need to curtail flaring.
Okay. And Wesco had intimated that they would come back before the board potentially yearly to address the situation if the pipeline still remains deactivated. Do you support a year requirement, or is there a recommendation the division has?
I think at the minimum or at the maximum length of time, 1 year, it might be prudent to say that Wesco should come back in 6 months, because we don't know the status of the pipeline or the PSC's ruling, and conditions could change in that period of time. So 6 months would be great, but at the maximum, come back in a year.
Okay. And in your memoranda, the division made 2 recommendations. After the testimony you've heard today, do you still believe that flaring should continue so long as the NGLs continue to be removed from the plant?
Yes, and I think that we also need to address any change in conditions. For example, new wells that are anticipated being drilled in that time that might cause more production to flow to the gas plant. But for the conditions as they exist today, we would support the flaring at the gas plant as long as NGLs are being produced.
Okay, and just to be clear, do you still believe that suspension of the flaring rule is warranted until the Greentown pipeline is reactivated?
Again, with the production scenario as we now know it, yes.
Okay. I don't have any further questions for Mr. Balza.
Mr. McDonald?
Mr. Baza, do you agree with the assessment that it's better to have the flare at the plant where the NGLs are stripped rather than on a well-by-well basis?
Likely so. It maintains a centralized point for that gas to be flared. It allows for the recovery of the NGLs. It just makes a little more engineering sense to be able to do it that way.
No further questions. Thank you.
Board members, any questions? Okay, start on the left.
2 questions. The 400 MCF that's being requested, I know you went into some justification of that at the last hearing, but I'd like to hear some of that again. It is now almost 3 times higher than what has been produced on average out of the well network over the past 3 months. So it is a significantly higher number, conservatively high number compared to what you're seeing report to the plant at this time. So could you just discuss the reasons why 400 is the appropriate number?
I selected 400 just to be, to have ample room for as I mentioned earlier, the 12-1, as well as some of these wells, as the oil drops off, the gas does increase a little bit, and the GOR will increase, and that kind of provides a level for that. We also have a well that used to be a very good well, and it died off, and then been kind of pumping it along, and has seen some slight increases here recently. So just to kind of have a little bit of extra room just in case.
When was the last time the network was producing up at 400 a day?
On the exit, I would say it's been, I don't know off the top of my head, but it's been over 6 months probably.
Okay. Second question, and this is open to anybody that can answer it. Do we have more information on the physical integrity of the pipeline? Is this issue more of a legal commercial issue, or is it a physical real world issue that's really preventing it from being put to beneficial use?
I think I could probably best answer that. I attended the Public Service Commission hearing where the Division of Public Utilities was seeking a deactivation of this pipeline, and the deactivation was essentially due to paperwork violations, not submitting inspection reports on this pipeline. There's testimony submitted at that hearing that indicated the physical integrity of the pipeline was likely in good condition, and if this pipeline were placed into the hands of a prudent operator, it could be brought back online in a manner of days. So as far as that's the testimony I heard at the Public Service Commission.
Thank you.
Can I follow up on that just for a second? What's the difference in your mind in terms of deactivation of it versus decommissioning? We heard the term decommission, which is basically to take it out of service. Deactivate it would be mothballed. Is that kind of your understanding? Would you please expound on that?
I think it's actually the opposite. There are terms of art with the Public Service Commission. And deactivation, it requires a physical, from my understanding, requires a physical disconnection from the facilities. But as far as it's not scrapping the pipeline in whole, and that's why it would be a pretty quick process, from what I understand, to bring the pipeline back online with the system.
A physical disconnection.
Yeah, I'm no expert on this. This is just the testimony that I heard. Is that it's a physical disconnection, but the engineering and the work on the ground to get it back into the system is actually a pretty quick process.
Other questions of the division, and then we're going to go to, I didn't ask the board for questions for Mr. Kirkwood, but we're on the division now, so go ahead. Mr. Hanson, do you have a question? Anyone else have a question? Yes.
This is actually for Mr. Kirkwood. You testified that curtailing the development of the wells may hurt the reservoir. Why are you considering putting in new wells?
For oil and gas operations, you're continually fighting a decline, so to maintain production where it can cover the reserves, or cover the cost of operation, and to grow a company or production in an area to drill additional wells.
Would you be willing to commit to not drilling new wells until this pipeline is active again?
I wouldn't have an issue with doing that as long as there was no lease ramifications of the two wells per year after the West Fertilizer EA has been approved, which, I would imagine this would be solved within that time frame very easily. But I don't have any problem with not drilling additional wells as long as it doesn't, because at that point, if you don't drill those two wells, the leases will be, would contract and the leases would be lost.
Thank you.
What?
Well, my question's for Mr. Kirkwood also. So should I ask that or wait?
No, go ahead. Let's ask
So-
all our questions.
Are you in a position, if you have the opportunity to take this pipeline over?
To operate it,
Mm-hmm.
we would be capable of operating. We operate DOT regulated pipelines elsewhere in Wyoming.
Okay. So when it comes through bankruptcy, if the price is right, you're in a position that you could just take it over and
Correct.
in control. Okay.
Hanson.
I've got a few questions. Let me start with the NEPA process. The draft EA has not been published, correct? You're still waiting on the archaeological studies to be completed?
Correct. I think it's been, I'm not quite the expert on it, but I think it's been completed. They're just waiting. The ARC surveys were done in 2015, and the ARC survey company is no longer around, so they're having issues with them lining over the current surveys with the GIS, and we can't ask questions to the people who did it, so they're having to redo chunks of it that didn't line up. But that, to my understanding, is the main thing that's holding that up right now. And once snow lifts, they'll get out there and do that.
There hasn't been a draft published.
I don't know 100% about the process, but I would imagine that not. But I don't know, unfortunately. Sorry.
Let's assume there hasn't been a draft. They'll issue the draft. They have to go through the comment period. Then BLM has to issue a FONSI, a finding of no significant impact, and that's appealable. It has to be published in the Federal Register. No, it doesn't. I'm thinking you're at least 6 months out.
That was what the last I'd heard was the guy said once this is done, they're hoping to be done with it in 6 months.
Good luck. The next question I've got is, if you go into the new lease area, was it the West Fertilizer Tract?
Correct.
I assume you'll be taking collection systems with you so that to each well
Yes.
that leads back to the processing plant?
Correct, yes.
So before you drill, you'll have those conveyance systems in place?
That they will probably be installed either as drilling or shortly after, but before production.
I guess my last question is a follow-up to a previous question that was asked. Is there a minimum number that you would be able to live with, less than 400?
I mean, I would say 300. More than likely 250. But I just really would hate to have it, particularly with the way that this works. We're a month in the rears on knowing these numbers flowing through the plant. of getting too close to it and then having a problem, not knowing it at that time. But I would imagine that 300 I would feel fairly comfortable with.
Okay, thank you.
More questions? I have a question, and thank you, Director Baza, for coming off the hill to be part of this hearing. Mr. Kirkwood, or council, one of the topics is reporting back to the board, and no longer than 1 year, but 6 months is recommended. The thought was that if the facts haven't changed and nothing is new, saving you, the company, and the board time with just a filing that everything would be just great, we're status quo, but that the 6 months wouldn't apply if there's a whole bunch of new wells being requested or other big material factual changes, that would trigger a report back, even if it's less than 6 months. Just wondering what your comment would be on that, because we don't need you to come to the board to tell us the same thing you told us last time that's unchanged. Mr. McDonald, you're free to comment on that too.
Well, again, we wanted to address the fact that the way that the request was drafted was, until the pipeline was put back in service. And I think when we filed it, the thought was that was going to be a short-term thing. The problem is with all the complications with the PSC and now the bankruptcy, and particularly if the bankruptcy trustee brings in the owners of the pipeline into the bankruptcy, there's so many uncertainties. We did want to recognize that, there should be some limitation or a certain period of time that Wesco would want to come back and report to you. I would agree with that. I'd say maybe it's 6 months, supply a report, maybe with a written report with an update, unless, like you said, there's tremendous factors, but I doubt there's going to be any wells drilled in the next 6 months that would change that amount, or if all of a sudden the wells got onto a huge amount and a huge amount of gas came. But again, like you said, if it's over the authorized amount, we would have to come back to you anyways for that. So I would suggest maybe a written report in 6 months, bringing you an update on anything that happened with the sale or the commissioning of it, and then come back in a year, if it's still at that point, to either seek further authorization and give you an update on the circumstances at that point that would justify further authorization.
Okay. Division, what do you think about that? If you understood the question dealing with the report back, what Mr. McDonald just said is 6 months written response, and then another one in a year. Kind of what I asked is, look, you take that same thing, 6 months or a year, or if there's significant factual changes, then that would in and of itself trigger it. Give me your response on that.
I think if there are significant factual changes, my recommendation would be that the board is immediately notified, especially if, somehow the pipeline goes back active, or there are really positive developments in that time frame. The one thing I would like to see in the report, and I neglected to ask Mr. Kirkwood, and perhaps you could still answer this question, is does Wesco have any time or any plans to re-stimulate the wells in this unit in the next 6 months?
We do have plans to do a stimulation on a well. Right now, that can be prolonged to allow or to ensure that we stay within the approved flaring allowance.
Okay. And then in terms of reporting, I think that would be another factor that should be included in the report to the board, whether it be every 6 months or a year. Plans to, operational changes in the field, re-stimulation, et cetera.
I consider that factual changes.
Okay.
Mr. Chairman, if I could just address that too. I mean, that's part of what Mr. Kirkwood's testimony was, why he wanted to have a little leeway to allow for that, and that's meeting your requirement to maximize natural resource production too. So that was the idea of the fluctuation there, to give a little leeway to allow those kind of things to happen without going over an appropriate limit.
More other question?
Just to follow up then.
Because we want to make sure we understand what we're being
Yeah,
proposed.
if you went through a stimulation, is it reasonable to assume that you could go up again to 400 MCF or get close to that? In other words, go above the 300 that you volunteered earlier?
I would say it's not overly likely. The stimulations they have not yielded, stupendous results, but just I mean, they have definitely increased reserves on the long run of a well, but they have not, not brought gas rates up to, 600-700 M a day or anything, any great addition. They're very small stimulations that just trying to cure some near wellbore damage.
So the board is informed on this. Will you kind of give us a definition of your idea of stimulation? Does it include just an acid job? Is it something more extensive than that?
The ones that have been done in the past they are about an 8-stage frac job, and they place around 20 to 25,000 pounds of sand per stage, and they use about 250 to 300 barrels of a mineral oil. The zone's very water sensitive, so we try to keep water off it as much as possible. But that's what's been done in the past on them.
But you don't have a fines, small particulate problem where you have to keep the channels open. You're doing it through fracturing then.
Correct. Yeah, we're trying to get past some near wellbore damage from drilling or whatever it is, and just the fracs are,
This is solve a near wellbore issue.
Yes, yeah, they're 10% of a standard stimulation.
Mr. Moon, did you have an additional question?
Same question.
I'd like to one more question. Please go ahead.
Can the natural gas be used to inject into the reservoir to increase reservoir pressure?
It hasn't been done in the past down there for additional pressure maintenance on a well. That's not to say that it may be an option, but a pretty extensive reservoir study would need to be partake in to figure out exactly where to inject, how best to do it, and if that would go to what kind of channeling you could see if you just inject it in and it shoots right over to another well, or if you're actually getting proper pressure maintenance out of it.
What kind of a reservoir is this? Is it water drive, or is it a?
It's just a natural depletion.
Natural depletion pressure.
Yep, pressure. Yep.
I'd like to take a kind of a break here, and there's a couple members of the audience that would like to testify or make statements. I'm assuming that these will be statements. If they did want to testify in terms of expertise, we'd like to have them qualify themselves. But if you would come forward, there are 3 chairs here. I understand there are 3 members of the public that would like to comment. The only thing that we require is that the record be clear of who you are, where you live, and who you represent. And then the second requirement is that you talk close to the mic, because I listen to what's being recorded, and then you can decide among yourselves which way, who's going first, second, and third. And so who's going to be first? Okay, we got to get that mic live. Hang on one second. Were you live? Okay, a little closer to the mic. Just pull it up to where you are.
Okay. Thank you, Chairman and board members. And
so identify yourself and give us your address.
Thank you. My name is Lionel Trepanier. My address is 1263 East South Temple in Salt Lake City. Thank you for this opportunity.
Do you represent anyone, or are you here on your own behalf?
I'm here on my own behalf.
And will you be testifying as an expert, or you making a statement?
I'm going to make a statement if you would have it there.
Okay, please proceed.
Thank you. I appreciate the presiding officer here giving us an opportunity to make these comments, and I appreciate if the board would factor these public comments into any final decision. I do recall counsel for the board had asked I would mention that I sent an email in this morning. So I did do that, and in fact, the email that I sent in is kind of the notes of the comments that I'm going to give to you now. My position is that the requested action, the action that's been requested would be unlawful. The division has recommended that the board suspend application of the flaring rule to allow the continued flaring of 400 MCF per day from that plant. Even though it would allow waste to continue, on balance with the other duties of the board, the division believes it presents the best option going forward. Well, that conflicts with the law. Particularly, I would point you to that in Title 40, Chapter 6, Section 1. This is Declaration of Public Interest, where it says it's declared to be in the public interest to foster, encourage, and promote the development, production, and utilization of the natural resources of oil and gas in the state of Utah in such a manner as will prevent waste. And the Declaration of Interest goes on, and it closes, the paragraph closes with this phrase, and the general public may realize and enjoy the greatest possible good from these vital natural resources. So the public interest is to promote development in such a manner as will prevent waste. Further, more specifically, there's a mandate at Section 40, sub 6, sub 3. It's titled Waste Prohibited, and it very simply states the waste of oil or gas is prohibited. That's the law in the state of Utah as I read it. It's absolutely clear. Now, the DOGA memo at page 7 states allowing the plant to continue flaring up to 400 MCF per day is permissible so long as the board suspends the applicable flaring rule, or in the alternative orders the director to suspend the flaring rule. Well, as I say, there's a specific statute that says waste is not allowed, but when we look at the rules specifically, the division points us to Rule 649-2-1, that's scope of the rules. And the scope of the rules state that these rules will apply, I paraphrase here, the rules will apply to all the land, and then I quote directly, to protect human health and the environment, to prevent waste, to protect correlative rights of the owners, and to realize the greatest ultimate recovery of oil and gas. So although special orders and rules, as subsection 2 of the same rule, this is 649-2, -1 said the scope of rules. Number 2 says that special rules and orders can be issued and shall prevail against general rules and orders. And I think that's what the division is suggesting that the board do. Order a special rule that prevails against general rules. But special rules and orders cannot prevail against the state statute. And that state statute is 40-6-3, waste prohibited. The waste of oil or gas is prohibited. Now, the deviation from the rules is covered in 641-100-400. That's titled Deviation from the Rules. And in there it says that in no event, and this is not the entirety of the rule, but this is how this rule closes, in no event may the board permit a deviation from a rule when such rule is mandated by law. So the rules that's preventing the flaring, the reason that WESCO is, and the division has brought this to you, is that this flaring violates the rules. The rule is in place because of a statute that says waste is prohibited. And the waste of oil and the waste of gas is prohibited. So it's unlawful for BOGM to authorize Blue Hills flaring without end. But there's another important issue that I believe the board has been misinformed on by the division. Economic waste is not a factor. DOGM's memo claims in making its decision regarding this massive flare The board should be mindful of waste, both economic and resource waste, and in addition, chose a path that provides the most incentive for a speedy resolution of the pipeline dispute. So the board, as the memo says, that they appreciate Wesco providing the alternatives, which the board insisted be brought here. But the division goes on and says, the non-flaring alternatives suggested in Exhibit 4 do not effectively balance resource waste, economic waste, and the resolution of the pipeline dispute. Well, that's not correct. The division recommends that the board, they recommend to allow the waste to continue, but preventing economic waste by oil producers is not DOGM's or BOGM's duty. DOGM is asking the board to balance economic factors that the law does not recognize and fails to even consider or even mention the public's lawful interest in protecting human health and the environment. DOGM has failed to consider the disruptive impacts and the costs of the huge unnecessary air pollution. 17 million pounds of CO2 would be produced in 1 year by burning 400,000 cubic feet of gas per day. That's simple mathematics. Just look at the carbon production and do the math. 17 million pounds. Many of the costs will come in the form of sickness and death because that's what local air pollution causes. Now, we should note that in DOGM's memorandum at footnote 8, they do note that the board is not statutorily obligated to prevent economic waste. In fact, I don't think the board is authorized to act based on preventing economic waste. Now, I want to address the alternatives that were brought. The division's claiming that quantifying the risks associated with curtailing production with any level of confidence is difficult, if not impossible, because of a number of variables and their individual and combined effects on production. Therefore, the division's opinion is that the risk involved in ordering curtailing outweighs the risk of flaring the gas. But it's illogical, and it's not based on fact. A lack of knowledge about the impact of curtailing production doesn't support an opinion that the risk involved in ordering curtailing production outweighs the risks of flaring the gas, particularly when the impacts to human health and the environment haven't been considered. One of the recommendations from the division has been to allow the plant to continue burning 400 MCF of gas per day until the pipeline's back up. As come out today in the questions from the board, there's nowhere near that much gas even being burned right now. So the permission being sought here is in fact not even just to deal with the gas that's currently being flared, but they're asking for permission to drill more and cause more gas to be flared. And that's not right for this board to do that. What is proposed is waste, 400,000 cubic feet of methane gas per day. That's the equivalent of the gas used in 1,923 households in Utah for as long as that flare is permitted. Waste is 17 million pounds of CO2 of Utah's carbon budget would be wasted every year. This natural or frack gas emits 117.1 pounds of carbon per 1,000 feet when burned. And the source of that is from U.S. Energy Information Administration, February 2nd, 2016. The Blue Hills flare seeks to burn 400,000 cubic feet of gas per day multiplied by 117.1 pounds each. That's 46,840 pounds of CO2 per day. Multiplied by 365 days, that's your 17 million pounds of CO2 emitted each year. This is waste. It's the waste of Utah's effort to improve air quality by reducing CO2 emissions. That 17 million pounds, if allowed to be emitted from that Blue Hills flare, that will erase the impact and the meaning of so many efforts by Utahns to improve air quality and reduce the CO2 emissions. So I ask the board, make the tough call here. That's why we have the board. Let's enforce the law. We can do better. Thank you.
Thank you. Will you please spell your last name for the record?
Yes. And that's T-R-E-P-A-N-I-E-R.
Thank you very much. Who will be next?
Okay. Is it on? Okay. My name is Ty Markham. I'm on the board of the Mormon Environmental Stewardship Alliance. And I'm not here to speak for the organization today. I'm actually here to speak for myself because I'm a resident of the area which will be directly impacted by additional flaring of these wasted gases. I'm also speaking just as a citizen of the state of Utah concerned about air quality, as of course my organization that I'm on the board of and a founding member of has been working very hard to improve in the state of Utah for many years.
Can you give us your address for the record and also spell your last name?
Certainly. Ty Markham, first name is Ty, last name M-A-R-K-H-A-M. My address is 150 North Center Street, Torrey, Utah, 84775. So I'm also here to speak as just a member of the general public, as a citizen of Utah and a resident of the area. I'm here to speak against the waiving of the flaring rule. And as my predecessor mentioned, this is likely illegal. Thank you. And would encourage you to think long and hard about approving the waiving of this rule, given that our legislature last year commissioned all of the Utah universities and colleges to come together along with other professionals appointed by the governor and the legislature, state legislature, to draw up a roadmap, it's called, the roadmap for Utah, to achieve our environmental goals, air quality goals, etc. And this would certainly fly in the face of all the goals that have been finally reported by this this study that has been done for over a year. It has been it's finalized now and presented to the legislature. Will be coming up in the legislature very soon, probably as a joint resolution. And I would like for you to just Google that, or at least find that online, a copy of that, because it's very enlightening. But I would like to just raise your awareness to that, that our legislature is waking up to the realities of climate change, as well as to the non-attainment of many of our counties, and to the health and well-being of its citizens. And I think this this issue deserves serious attention to those issues. Thank you very much.
Thank you. Next speaker.
Good afternoon. My name is Dennis Mullen. Last name M-U-L-L-E-N. I live at 6921 South Country Home Lane in West Jordan, Utah, 84084. I'm just here as a private citizen, and I'm concerned about climate change. And my only comment is that climate change is an existential threat to our planet. And the Blue Hills flare is going to only exacerbate that problem. In light of Governor Herbert addressing this issue by putting $100 million last year towards fighting climate, I think this is something we need to address, and I'm against the Blue Hills flare project, and I'd appreciate the board if they would consider that. Thank you.
Thank you. Would you mind if the parties and the board asked you questions so that we make sure we understand your point? Council, I know the board has some questions. Would you like to ask any questions or clarifications at this time?
I'd just like to ask Mr. Trepanier, I'm sorry, is that a proper pronunciation? Are you a lawyer? I'm not. Are you an environmental expert?
You speak into the mic, please. I can't, but you're not picking up on the recorder.
Let me ask you this.
My work as an adult has been in the environmental work all of my adult life.
Okay, are you a licensed, or excuse me, a graduate of environmental sciences?
I'm not.
Okay, are you a petroleum engineer?
I am not.
Okay, thank you.
Okay, division, any questions of these? Of the pub?
No questions.
Board members, Mr. Hanson, do you have a question you'd like to ask?
Yes, I don't want to butcher your last name, so I'll call you Lionel. Is that all right?
That'll be fine. Thank you, sir.
How does the board balance the problem of expert testimony that says if we shut in these wells or curtail the production of these wells, that could result in reduced production of oil and gas in the future, against what you're saying is waste by flaring this gas on a temporary basis? In other words, if they curtail production from these wells and we can't produce the oil and gas that we would have been able to without curtailing them, isn't that waste in itself?
Well, what I would say is the testimony that we heard was speculation. There was no actually direct testimony that curtailment would cause damage to these wells. It was speculation, and the speculation actually didn't seem to have much of a factual basis to it. But further, that's not the only alternative available. Putting that gas into, getting that gas to market would negate the need to flare it, and also not, what would they call that? Stimulating the wells wouldn't increase the gas production. It wouldn't increase the need for more waste.
I understand that part of the argument. The part of the argument that I'm having a hard time with is if we were to claim, well, let me say this a different way. You're saying that they're speculating.
They're speculating about curtailment, but I don't think the board has to order curtailment. All the board has to do is decline to give permission to flare 400,000 cubic feet of gas every day.
But in a sense, that requires them to throttle back their production.
That's one of the alternatives that we saw that they came up with, but there were other alternatives likewise.
Certainly, the expense of those other alternatives would essentially make this whole project uneconomical, is essentially is what their testimony is.
Well, I didn't hear that direct testimony, but what I did hear was that Wesco has done things in November and December that reduce the amount of gas being produced, that they can actually move the amount of gas being produced up and down. That was the testimony that I heard.
Well, I guess I disagree with your interpretation of that testimony, that they were not curtailing the production on a long-term basis. Their curtailment or the reduction in production may have been related to operations at the wellhead that required them to, for a short period of time, curtail production.
So that proves the point. They could curtail, and they chose to do that themselves.
I guess two things. One, we have to accept that this is an expert in the field of reservoir engineering, and that he actually has a educated and experienced opinion about what curtailment of production of these wells would result in.
We heard the basis of his testimony, and I mean, you saw what the basis of his testimony was. It wasn't based on a study. He said he looked at some old wells,
which showed reduced production and recovery based on curtailment of production.
Well, I don't know that all of that was in his testimony. I guess you could assume that that was but I would say that testimony, to me, didn't establish that that he had the knowledge that a curtailment was going to damage that reservoir. Didn't hear it.
Are you a reservoir engineer?
Well, I am not a reservoir engineer. I was just listening to the testimony.
And I guess it would be my opinion that if you don't have the expertise in reservoir engineering, it would be difficult, and I'm not an expert in reservoir engineering, but it would be difficult for me to tell an expert who has experience and knowledge that he's wrong, simply because I don't understand it or don't agree.
Okay. Well, I see what you're struggling with there, but I think the real thing that you have to hit is that the statute says that waste of that gas is not allowed.
Well, and then that goes back to my original question: is if we curtail and we accept his testimony, then waste is occurring by simply curtailing production.
Well, as I said earlier, I don't believe the board has to order curtailment for Wesco to be able to pump their oil. They don't need curtailment. It's not required. If they chose curtailment, that's because that's their property. What we're looking at here is not running their business for them. It's not the board's responsibility to make that an economic business. They made their decisions. They put their chips on the table. We have to let them fall. The law is what the law is. They put their chips on the table. Lay their cards down. Let's see what they read.
I appreciate your testimony. Thank you.
May I make an additional comment just regarding the economics of this issue? It sounded like that was one of the reasons why that they're here today, is because it's economically not feasible to do certain things to capture the methane, the excess gas. There's also an economic issue in how this will affect the businesses and tourism in the area in which that is located, the Blue Hills plant is located. And I think that economic activity affects quite a number of businesses, including my own. I actually run a tourism business in Torrey. And it's near, as you know, many national parks right there near Capitol Reef and Arches and Canyonlands, et cetera. So there's going to be economic impact from flaring this much excess waste, as you might call it. And it's going to be not only health related, but economic related. It's going to hurt tourism industry in our area of Utah, which is not insignificant. Thank you very much.
Thank you very much. Other board questions? Seeing none, Division, will you sum up your case in chief then? And then we're back to Mr. McDonald for your summary.
Mr. Chairman, I believe Mr. Wes Adams from SITLA is here too, would like to make a statement.
Oh, I didn't. Okay, I didn't know that. Thank you. If you'll come forward. Please identify yourself and who you represent. I'm not picking up on the mic at all.
There we go. My name is Wes Adams.
Closer, Wes, if you wouldn't mind.
Is that working?
No, I'm not.
Hello? Check.
Let's try that.
Wes Adams. I'm the Assistant Director for the Oil and Gas Program at CITLA. That's the School and Institutional Trust Lines Administration. I'm here today because we have an interest in this produced gas and oil. The oil does come from the Cane Creek unit, which we have a 10% ownership in. And in this region, it's very rare for us to try to monetize on oil and gas. So any type of waste does concern the trust from a revenue standpoint. Mr. Hansen, earlier you asked about the NEPA, the draft EIS, and currently the Moab Field Office is handling that. EIS for the West Fertilizer, 15 well pad APD, but that is not yet to a draft. So, the West Fertilizer.
Did you say EIS or EA?
Yeah.
Okay.
Thanks for the correction. So it is an environmental assessment. It was submitted back in 2015, and we've been waiting for a draft to make comment on. But as it relates to the matter today, we support Wesco in their request here, relief for 400 MCF a day, which would be residue gas preserving NGLs and oil. And that's the argument here, is that we're more concerned with the preservation of oil and NGL because we think that that has more monetary value. We would like to see the gas being sold down the line, but on a revenue standpoint, that's the lesser of two evils. And until we can get a resolution with the pipeline, I feel that this is the least detrimental outcome for us as a trust.
Thank you. Would you submit to questions?
Sure.
Any questions? Hanson.
One quick one. is the company paying royalties to Sitla on this gas that they're flaring?
They are. They are. So they're taking an additional burden above and beyond what they should normally have to accept, and we appreciate that from Wesco. They're paying, I believe, the BLM and Sitla royalty on flared gas, but we continue to get the NGL royalty as well. So right now, you know, if you want to look at what we've benefited over the course of this unit, $9 million in oil royalty, about $30,000 in gas royalty, and probably $40,000 in NGLs. So out of that revenue stream, natural gas is the least detrimental. And just for reference, in 2015, when the board approved flaring out here, it was for $4 million a day, and we're talking at 10% of that now.
Could you briefly explain for the record what Sitla does and what these royalties are used for?
Yeah, absolutely. So we're mandated through the legislature to create revenue for the permanent fund. And any way we can do that through mining, oil and gas, surface industrial, or real estate development. We also are involved in solar. I'm charged with leading up revenue generation for oil and gas. And so historically, we make about $40 million a year, which goes into a permanent fund. It's currently at $2.6 billion. Each year, those earnings kick out endowments to the school system, and last year it was $76 million to public schools. So when we look at preventing waste and monetizing resources, the argument, I'm just extrapolating here again, but if we look at the uncertainty of shutting in a well, I'm not guaranteed that the minerals will be reproduced after the wells come online, and that's what concerns me, is nobody has evidence to say that shutting in a well will either kill the well or not kill the well with certainty. And I think until we know that, it's very dangerous to make a determination on that aspect. So Grand County, we don't have a whole lot of mineral production. In San Juan, we have a little bit, but the heart of it comes from Uena and Duchesne County, and currently the only producing asset we have in Grand County is the one we're talking about today. And I would say that the field has declined dramatically since 2014 to the order of 90%. So this is not perpetual, this is temporary.
Mr. Church.
I have a question on royalties that are paid to you on flared gas. Are you paid royalties on gas if it's flared at the wellhead or in the plant? And if it's at the wellhead, on what basis? On a BTU basis or just on an MCF basis? And if it's at the plant, if it's stripped out with the heavies, does that increase your royalty on the gas as such?
So the basis of payment is on a BTU, on the throughput through the transportation line, which we are currently prevented from doing. We've never actually been paid royalty on flared volumes at the wellhead, because at that point in time, when they were flaring at the wellhead, we were actually getting paid on royalty from the oil, and they were constructing gathering line, trunk line, and transportation line for the Blue Hills gas plant. There was $30 million spent on the gas plant back in 2014 by Fidelity. So there's a valid argument to be made for that good faith effort and the infrastructure that was created to help preserve oil production and actually safely handle gas rather than resorting to a flare and protecting the environment.
Other questions? Yes.
How old is this pipeline we're talking about? Is it only 2014? Is it only 5-6 years old?
The one that is shut in was put in by Delta, and that was probably in the 2000-ish range. The line he's referring to is the line that we currently operate.
Okay.
It was installed by Fidelity in the 14-15 range.
Thank you. Okay. Any second thoughts? Okay, division, is there anything else that you would like to give us?
No, I think you've heard our recommendations, and yeah, we have no further case to present.
Mr. McDonald, for summation or additional.
Yes, thank you, Mr. Chairman. First of all, I'd like to get on the record the objection to whatever was submitted by Mr. Trepian today. I didn't receive a copy of it, and I would object that it's untimely. So if his statement is sufficient, then it should be given the evidentiary weight as a statement.
Yeah, I think that's the position of the board, is that it is a statement.
Okay.
And will be given the weight according to that level. It's not rise to the level of evidence.
Okay, thank you. You've heard the testimony now in 2 different hearings. This is a multi-million-dollar plant and a gathering system that was put in to deal with the gas from this field. It was intended to avoid flaring if at all possible. You've now heard all the options to be considered and the economic values of those and the problems with it. And again, the point I want to make is that legally they could flare at each wellhead and have 18 flares that aren't as clean a burn, and also losing NGL revenue stream, and they could legally do that today. And it seems to me it's pretty obvious the best opportunity here is to leave it at 1 flare that burns better and stripping out the NGLs. Now, again, this is an unusual circumstance. I would normally say, you know, obviously that's why the regulation's in place, that you don't want to have flaring at a gas plant. But the unusual circumstances here are we are out of the control. This is beyond Wesco's control because of, number 1, the PSC orders, and number 2, the bankruptcy. Wesco's testified that they're using their best efforts to try and remedy the situation. I think it's appropriate. You have now the division's memorandum that supports it technically. Again, nobody wants to see this happen. You've heard Wesco is paying royalty on gas that's being burned. They're not even getting any revenue from it. Obviously, it's in their best interest to try and get the gas through the pipeline and to sale, and that takes care of the problem. I think that the statutory requirements have been met. I do want to point out that, yes, it says that waste is prohibited, but as Mr. Hansen's pointed out, waste is also when you don't produce and maximize natural resource recovery. If you leave the oil in the ground, you're committing waste. Also, I want to point out the statute says and gives this board the authority to allow flaring of gas from an oil well, with the recognition that that doesn't necessarily transfer to the weight that it's talking about being prohibited here. So I think you've heard plenty of evidence. I think you've heard it from the experts that the best option right now is to allow this. Wesco's more than willing to come back and put a limit on this. We talked about some situations with reporting back in 6 months and having this no more than a year. And the other factor was that I said with that was up to a year, but if the pipeline becomes effective, obviously the need for authorization for flaring ends at that point, and they would want to sell the gas. So I think all statutory requirements have been met. We would ask the board grant the request with that modification of timing and reporting back to the board. And we thank you for your time and efforts at the last 2 hearings.
Thank you, Division, Wesco, the public, and SITLA for your comments. We appreciate that. Board members, would you like to take a 5-minute break, and then we'll meet in chambers to discuss this? I would ask you not to discuss this until you get everybody there, because I don't want anybody missing it. So we're on a 5-minute break, and then we'll meet in room 1010. Thank you very much. I got it. It was turned off by me. Okay, we're back on the record. The board has reviewed the evidence, testimony, comments, and have a general comment and then its decision. We'll ask Mr. McDonald to prepare the order consistent with this.
Mr. Chairman, may I interject just briefly? I inadvertently failed to admit or move for the admission of Division's Exhibit A, and I'd like to do so at this time.
Well stated, yes. Board members, any objections to that? Thank you. That is admitted into evidence.
Thank you.
The general comment is that, generally speaking, we are, as a board, against flaring of natural gas. It's something that we would prefer to avoid. We recognize that there are circumstances. We were hoping to avoid it in this case to the point that the board sent its attorney and the division sent its attorney to the Public Service Commission hearing to let them know that we had issues with deauthorizing the pipeline, and we wanted them to be able to make an informed decision about that. But we also recognize that Wesco has done nothing to inherit this problem, that this came about by third parties. We recognize the school kids of Utah have a 10% interest in the production from this field, and that the optimized amount of total revenue to the kids occurs if flaring could occur, and that optimization is important in our total decision. We recognize that there are arguments for doing what we're doing and against what we're doing. Having tried to balance all of that into a decision, it is the decision of this board that the request for agency action is approved, that the limit on the amount of flaring will be 300 MCF a day, unless you let us know otherwise, and that the reporting will be a written report in 6 months, and then the earlier of one of the two things. The one would be a 1-year period after that, or to a material change in circumstances and economics of the field. And I need a little help here on what everyone understands a material change. If you're doing a whole lot of recompletions or frac jobs, or you want to propose new wells, or the economics change, or the pipelines put back into operation, all of those are considered to be material for the purposes of this discussion. And I invite board members to enhance on what I just said, enlarge on it. Mr. Borden.
I just wanted to add all those conditions.
You're not.
Just wanted to add all those
I still don't hear you. Let's see.
You don't hear me now?
No, let's just see. I guess I can just put this on.
Oh, yeah.
I got you.
That's all predicated as long as the Greentown pipeline remains inactive, of course.
Correct.
That was understood. That as soon as that's back in line, the authorization ends.
All right. And so a motion is in order to do that. And I think all you need to say is so moved.
So moved.
Is there a second?
Second.
All in favor of that motion, say aye.
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 Any opposed? Let the record show that that was unanimous. We had quite a debate on this issue. There were strong feelings on all sides of the issue, and we recognize that this was a hard-fought compromise that was being presented to you as the board's decision. With that, that concludes this matter unless something else has to be brought up. And I believe there's nothing else on the docket. Is that a correct presumption? Thank you, Council, for your involvement with the PSC and on this matter. Thank you to the public that commented.
Thank you.
With that then, if I'm correct, there's no other matters. Mr. Begley, is that correct? We've finished everything?
That is correct.
Okay, a motion to adjourn is in order. I would ask, well, hang on a minute before we do that. During the lunch break, each of you was given a copy of the proposed legislation. In principle, not to the exact wording, but in principle, I'd like to take a straw poll of the board as to their level of whether you could support that, where we are going. So it's not going to be in terms of a motion, but all those that can support the architecture that we're trying to move forward. You don't have it?
I have it. I did not have it.
Okay. But if we had 6 out of 7, would that be okay? Or those? I understand there's a high level of trust here.
Can you give us a couple?
Yeah. Then why don't we take about another 5-minute break and then, or 10, and then we'll get a feeling for the motion, and then we don't need anybody else to stay, do we? So with that, then, we'll just be on a short break.
Well, you just have to find the underline.
We're back on the record. As soon as you're ready. A motion to adjourn is in order. So moved. All in favor say aye.
Aye.
Any opposed? We are adjourned. Thank you.